Hey, welcome once again to Employment Hour in 30. John Scholes, Lior Samfiru. We are here to talk about employment law, workplace rights, and fill your head full of useful knowledge for a change. It's stuff that you need to know. It's what, 80,000 hours a year you're at work, so it's good to know your rights. And when you're not handed something that you should be handed, like a bad severance offer. We have lots of stuff to get to on the show today. We'll get to the severance pay calculator, but first, the week that was. What do you have for me, pal?
80,000 hours.
I don't know. It's a little,
I don't know what kind of a job you have, John. That's a lot of hours.
Welcome to media.
For most of us, it's more like 2,000, but that's okay. But it is true that we spend so much time at work. We spend more time at work doing our job, than we do anything else. More time than we spend with our family, more time than we spend on vacation, unfortunately. Yeah. So it's important to know our rights. It's important to know what we're owed. It's important to know how the law protects us, because sometimes things are going to be great at work. Sometimes your issues are going to be non-existent, but sometimes things happen, problems happen. Your boss may have done something. The company may have gone through some changes. Maybe you've lost your job. What does it mean? What are your rights? What can you do? What should you say? Well, all those things are things that we discuss on this show every week. We discuss them all the time. And if you want to know something about your legal rights, we can talk privately as well. We'll give you my contact information throughout the show so that we can connect, phone, email, no problem. But every show, I want to start off with the week there was, a situation that came across my desk just over the past few days. I spoke with a gentleman, John, who had worked out for the same company, get this, 39 years. A lot of respect for that. If you can work at the same company for that long, obviously did a good job. You don't make it to 39 years if you don't do a good job. He was older, 65 or 66 years old, and everything was fine up until very recently when his boss started making some not so subtle hints, I should say, about his retirement. So, when do you want to retire? Should you consider retiring? Why aren't you retiring? Oh, do you really want to continue working here? This is no fun. You should
Here's
spend
a nice retirement home.
Yeah, right there. But no, you're laughing. He actually found a retirement brochure on his desk. And needless to say, you and I can joke about this, but this made him feel very uncomfortable. Yeah. He had no plans on retiring. Frankly, I don't think he could afford it financially.
He didn't have to. He doesn't have to.
And he doesn't have to. But it made his work environment very uncomfortable. Clearly, the company was sending a message. They don't want him there. No. They think he's too old. They think he should leave. And, it doesn't get much more subtle than a brochure on your desk. So he called me very upset and wanting to know, what do I do here? I mean, how do I continue working when they're telling me, essentially, you're too old, leave? Yeah. Well, here's the thing, John, and you've alluded to this. First of all, there's no such thing as mandatory retirement. A company can never force you to leave at a certain age. Whether you're 65, 75, 80 years old, hey, more power to you. You can continue working. But in a situation where the company is clearly sending you the message that they don't want you there, that you should be doing something else, that your time has come and gone, that in and of itself is age discrimination. Creating this environment, this situation where you're not comfortable working, where they're essentially telling you you're too old. That's inappropriate. That is discrimination. That is a violation of the Human Rights Code. So here's what I told him. I said, just by putting you in this situation, by sending you these not so subtle hints that you should be leaving, they've discriminated against you. Therefore, you can treat that as a constructive dismissal. After 39 years, he's going to be owed at least 2 years' pay, potentially human rights damages as well. A company is not allowed to do that. If your employer mistreats you, punishes you, lets you go, tells you should be leaving because of your age, that is illegal. You cannot be put in that situation. Your employer is not allowed to do that. And by doing that, not only is that, of course, a human rights violation, it's illegal, you can treat that uncomfortable situation, that poison situation, as a constructive dismissal and leave with your severance. And that's what he's going to do. He was very relieved, and it's also not a good way and a respectful way to treat someone that's been with you for 39 years.
Like, let the guy ride off in the sunset when he wants to. 4 decades of working for you. Like, have a little respect for the guy.
Terrible situation, but, unfortunately for the company, they're going to have to pay. But there's an important lesson there for our viewers. We do have an aging workforce, okay? Yep. It's statistics show that now. And you may find yourself in a situation where the company's saying, hey, you know what, maybe kind of you should leave.
Here's your hat, what's your hurry?
Yeah, exactly. Can't do that, though. Yep. Illegal. And if you ever are in that situation, give me a call. I want to talk to you.
EmploymentHourTV.ca, the place to go. You want to find where you can catch one of our radio shows every week. We get a ton of phone calls on the show. We got our pal Ryan to chop them up nice and neat, and we play them back in this show, and we talk about them. First call of the day is coming up right now.
2 years ago, I got into a accident, and I have doctor's papers backing me and stuff like that. And basically, I'm at the point where financially I have to go back to work. And I was like, so what about going back to work? And they were like, sorry, you no longer have a job here. This was said to me by a secretary. I was a forklift driver in a warehouse, 10 years, 38.
This is actually, John, a very common situation. You go on a medical leave. Sometimes the medical leave is extended or is lengthy, and then the company says, what are you talking about? You don't have a job here anymore. Well, not so fast. Let's start with the idea that you can be on a medical leave as long as you need to, as long as a doctor backs you up, whether it's 2 weeks or 2 years, as in this case. And the thing is, when you're ready to come back to work, the company has to make all efforts to take you back. They can't say, oh, it's been too long, or we don't want to, who are you? They can't do any of that. They have to try. If they've tried legitimately, they've looked everywhere, and they cannot, then it just is a termination. They still have to pay you severance. If they don't try, that's a human rights violation as well. So bottom line is, for this person, for everyone else that's on a medical leave, you get better when you're off. Do what you need to get better. And when you're ready to come back to work, the company has to make all efforts to take you back. So we've already established that this person is owed severance, potentially also human rights damages. But let's talk about the severance piece, how much he's owed. Not only can I just tell you, let me actually show you on severancepaycalculator.com, which you can check out for yourself, what this person is owed. You can see that on the screen right now. He's a forklift operator, been there a total of 10 years, 38 years old. Obviously, he wasn't paid any severance, completely wrongly. Severance Calculator correctly assesses him as being owed 8 to 10 months pay. 8 to 10 months, you can see that on the screen. So this information, we just went to severancepaycalculator.com. We'll talk about that more later on the show. But potentially also human rights violation as well. So remember, if you're on a medical leave, company has to take you back, or at least make all efforts to do so when you're ready to return.
And those efforts also include if you have any medical restrictions, like when you left the company, you didn't need to sit down. Now you have to have a sitting job because of some accommodation, right?
Exactly. We call that accommodation. So sometimes you may be able to come back to work, but not exactly the way you were before. You may need some modified duties or modified hours, maybe ability to work from home, maybe do some help doing your job. Company has to accommodate. It's a strict legal obligation. Even if it's difficult, even if it costs the company some money, they still have to do it. So if a company refuses, no, we don't have to do that. Too bad. You want to stand, go find another, or to sit, find another job. No, that's a human rights violation. One of the most basic obligations that an employer has is to accommodate. If your employer doesn't accommodate when you need to, make sure you talk to me right away.
1-855-821-5900 is the number. Another resource for you, terminationquestions.com as well. You can ask your questions there, and they get answered either by Lior or a member of his team quite quickly. I'll read one to you, Lior, and I know you want to talk about it from terminationquestions.com. First one of the day says, I was terminated without severance after receiving one written performance warning. The company policy says that if we don't meet a performance requirement, we will be given a written warning and provided with additional training, which didn't happen. Was I wrongfully dismissed?
So the interesting thing is what he did not tell us in this question is, was he let go for cause?
Right.
In other words, did he get severance? Because if he was let go supposedly for cause, the company's saying, oh gosh, your performance is so bad that we can let you go without severance. Yep. No, what he's describing is absolutely a wrongful dismissal. There's a couple of reasons for that. Number one is the fact that the company itself didn't meet its own policies. If a company's policy and that you've agreed to is that we'll give you 3 warnings and then maybe we'll let you go, and they don't do that, they skip steps, it's going to be that much easier, I should say, to show that that's a wrongful dismissal, that you're owed compensation. And beyond that, of course, remember, it's always difficult to terminate for cause. Even if his performance was not good, the chances of them actually being able to terminate him for cause are very, very small. Now, if they terminated him without cause, in other words, with severance, yeah, they're allowed to do that, even though his performance was not that bad. As long as they pay proper severance, a company can let you go for good reason, not so good a reason, they have to pay severance. So depending on whether or not it's cause, in which case it will be a wrongful dismissal, or without cause, in which case he just needs to make sure he got his proper severance.
What comes with your severance and your severance papers is a deadline. It's on all severance offers, whether it's short, long, it makes you nervous, it doesn't matter. We're going to talk about it. Everything you need to know about a severance deadline. Talking points, about 6 of them here, pal. First one is how is a typical severance offer structured?
So a severance offer usually looks the same. Most look the same, where a company is going to outline, we're letting you go. It's going to outline then what they're proposing to pay you, And then it's going to have a deadline. So here's what we propose to pay you, employee. And to accept this, you have to sign this, this document, which includes a release by Friday at 5, Tuesday at 2, whatever that deadline is.
Okay.
So there's the termination, there's the offer, and there's the deadline. And that's what we want to talk about, because that deadline, that pressure tactic, is what makes people sign inadequate severance packages. It's what makes people sign off on less than they're owed. That's an important thing to remember that, and we'll talk about exactly what that means and what to do if you're facing that deadline.
So should someone that has been let go be concerned about that deadline, and what happens if they don't sign by the deadline on that offer?
So I'm going to be very clear here, John. That deadline is meaningless. Okay, I've said this, I'm on TV, I can't take it back. That deadline is meaningless because your legal rights don't expire Friday at 5. Your legal rights are what they are. Either you're owed something or you're not. And if you are owed something, you have 2 years to pursue those entitlements. That deadline is a pressure tactic. That's all it is. So think about it this way. Most people are offered a lot less than what they're owed. And then there's a deadline to accept this inadequate offer. So in other words to put it is, if I owed you $100 and I said, John, I'm only going to pay you $30, but you have to accept by Monday, you'll say, no thanks, Lior, pay me my $100. Well, that's the same with the severance package. If you're owed 18 months pay and you've been offered 7, as long as you accept by Friday, why would you accept by Friday? You're owed a lot more than that. That's why you contact me. That's why you go to severancepaycalculator.com and you don't mind that deadline.
You know that, I know that, our viewers now know that, so why do employers bother putting it on there?
It's a pressure tactic. Think about it, John. When someone loses their job, they're not in the best mind frame to make a decision. They lost their job, they didn't expect that, they have still bills to pay, they're worried about finding another job, and in that mind frame, they're getting a deadline. You have to sign this by Friday or else. In that bad mind frame, most people are going to make decisions that they wouldn't otherwise make. They'll sign off without thinking about it, without getting proper advice, and it works.
Yeah.
In many of these situations, individuals are going to sign it because they feel that deadline. I get calls all the time from people saying, Lior, I signed it because I felt the pressure of the deadline. Can I get out of it? Usually the answer is no. So now you know better. That deadline is meaningless. Don't sign it. Call me. Go to severancepaycalculator.com instead.
Calling you means getting legal advice, and if people panic, they don't necessarily know where to go right here. But if they haven't had the time by the deadline, can they ask for more time?
So first of all, remember what I just said, that you can not worry about that deadline. But as a courtesy, and I believe in courtesy, I would ask for more time just to be courteous. I need some more time to consider it, so I'm going to get back to you instead of Friday by next Wednesday. And that's fine. Out of courtesy, you can do that. You don't have to. You can simply say, I'll get back to you when I'm ready. But do that courtesy if you want to, but there's no reason not to check up on your legal entitlements right away.
The pressure can get to people quite quickly. As you mentioned, they're under a lot of stress. They're not thinking straight. So they've signed the severance offer because of pressure. Can they take it back? Is there anything they could do?
That's probably the question that I hate the most, and I get, unfortunately, very often. People calling me or emailing me because I actually had one this morning because they signed off on that offer. They weren't in the right mind frame, and they realize now, holy cow, I was owed another 8 months pay, another 15 months pay. What do I do? This person that emailed me this morning, he was paid 6 months severance. He accepted it. He was owed 18 months severance. He worked for the company for 20 years. Unfortunately, despite that pressure tactic, once you sign it, in most cases, you're done. You can't get out of it. I can't get you out of it. You only have one shot at it. So please do not sign that severance package before you get advice. When you find out later that you're owed another year's pay, like that person I mentioned, you don't want to be in a situation where you can't pursue it. That's a terrible place to be in.
What if the deadline is such that it's, we need you to sign this before you walk out the door?
That's different.
Right.
That happens rarely, I'll say that. But if it doesn't, I've seen it happen a few times where, no, you sign this now or else. In that situation, if the company is essentially blocking you from leaving, you have to sign this now, that pressure may be so much that we can potentially get you out of it if you did sign. But if the company gave you the time to look at it, to consider it, even though you didn't, but you had the opportunity, if you signed it, you're stuck with it.
Everything you need to know about severance deadlines. Finally, you've been handed one, a deadline severance offer. What do you do? Where do you start?
Well, first thing you do is you grab your smartphone. We all have them. Grab your tablet, whatever it is. Go to severancepaycalculator.com, and you can find out in seconds whether what they've offered you is adequate. Otherwise, reach out to me. Reach out to another employment lawyer. If you don't want to talk to me, that's okay, and I'll refer you if you want me to. But bottom line is, get some advice. Make sure you do the right thing for yourself, for your family, because if you don't, trust me, you'll regret it later.
You mentioned Severance Pay Calculator. Pardon me. We'll get to that in more detail after a short break. 1-855-821-5900 to reach out. That is the number. Lots more. Employment Hour 30 is on the way. Don't go anywhere.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. Severancepaycalculator.com.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to inyourcorner.ca. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
You probably know by now, if you, this isn't the first time you've caught the show here on Employment Hour 30, severancepaycalculator.com, the first stop you make if you've got a severance offer, or even if you're just curious for that matter, how much you would be owed if you ever you lost your gig. Tell me about it.
So over 750,000 people.
Is that where we are now?
Yeah,
Wow.
over 750,000 people have used it. One day we're going to be over 1 million. That's going to be crazy, insane. I'm very proud of that. We created it some years ago to allow people to find out easily, quickly, accurately what they're owed if they lost their job. So that's what you do. You go to severancepaycalculator.com, grab your smartphone, do it right now, and you can find out what is your entitlements. What are your entitlements worth? Whether it's 6 months, 12 months, 24 months, or anything else. It's easy, it takes seconds. It's anonymous, it's free completely. There's no strings attached. I'm not trying to lure you anywhere. I'm just trying to make sure you have that information that you need. So whether you've just walked out of that termination meeting holding those severance papers in hand, or you're worried about the status of your employment, or you're just curious, works just the same, severancepaycalculator.com. And the reason we created it, it's because it's not a week's severance per year of service or 2 weeks per year of service. It's based on 3 factors: your age, your position, the length of your employment, and that is what the calculator does. It looks at those, assesses those entitlements, those factors to determine how much you're owed. It's a lot more than you realize, and the nice thing about the calculator, there's a nice little green button at the, on the bottom.
Yep.
If you want to, and only if you want to, you can press it to contact me directly so that I can actually help you get what you're owed.
And if you're an employer and you want to do the right thing as far as compensation is concerned, there's an employer mode there as well.
There's an employer mode, just as easy to use, just as free. To allow employers to find out how much they have to pay an employee, and also give them some additional information that's useful to them to make sure that they comply with their legal obligations.
You bet. We'll run an example through the calculator now that we do every week. 59-year-old Alex was an accountant at a federally regulated company for 3 years. He was let go. He was told that because the company is federally regulated, his severance would be 1 day per year of 1 day per year of service. Is that all he's really owed?
So, how many misconceptions are there? A week per year, a month per year, 2 weeks per year, a day per year, apparently.
He gets 3 days.
3 days, that's not bad. Come on, gosh. The reason why we're here on this TV show, the reason we do our radio shows, the reason the severance calculator exists is because of these misconceptions. So, of course, that's nonsense. But what's important to remind everyone is federally regulated employees, their severance is calculated in the same way as provincially regulated employees. Your full entitlements are the same, whether you're a federally regulated employee working at a bank or a provincially regulated employee working at a grocery store. They're calculated the same way. Don't believe me? Let's try severancepaycalculator.com for this scenario that you just read out, John. So this person is a professional, worked for a company for 3 years, 59 years old, and it was offered, ta-da, 3 days. Sweet deal. Except severancepaycalculator.com, as you see on the screen, correctly assesses him as being owed 6 months' pay. 6 months' pay. Okay, so not 3 days, not 3 weeks, not 3 months. 6 months' pay is what he's owed. Provincially regulated, federally regulated, works just the same. Check it out. How much are you owed?
EmploymentHourTV.ca, the place to go to find the radio show. Call number 2. 2 for today, I think it is. 2. How's my math? I should be getting 3 days severance. Call number 2 is coming up right now.
I have a booked holiday. It's 1 day. My boss agreed to it. Now he's trying to say that I have to work. Probably approved about a month ago, and the holiday is next Friday. I'm traveling over the border for a concert, which I've already bought tickets for, booked hotel, etc. And I'm just wondering what can be done. Do I have any rights?
Yeah, she's already bought tickets and
You
everything.
know, you think that this scenario would be rare, but I can't tell you how many times I've gotten calls, emails, exact same situation. I booked a vacation, it was approved, made arrangements, now company says, can't go. It doesn't work that way. Now, a company does have a right to schedule a vacation. They have a right to tell you when you can take vacation and when not. They can.
Yeah.
But if the company says yes, and you rely on that, they can't just take it back. So, if it's one thing if the company said, no, we don't want you to take vacation, but the approval just happened, you hadn't yet booked anything, then you are expected to move things around. But if you relied on it, you booked your trip, you made arrangements, reservations, you paid money, the company can't force you to change it. The company can't take the approval back. At that point, it's the company's problem to deal with. So in this particular situation, this call we got on our radio show that we just heard, no, the employee doesn't have to cancel her vacation. Her employer can't penalize her. That's the key. She can't be penalized, fired, disciplined in any way because she's taken a vacation that was approved. If your employer tries to take away the vacation that they've already approved and you've relied on that approval, talk to them. Be reasonable. Make sure that they're reasonable. If they're not, if they still don't care, they insist on you canceling your vacation, talk to me. I'll help you resolve it.
Does that also apply for somebody who's been, say, working at a place and for the last decade they've always taken the 3rd week of June off? Every year for 10 years they've done that, and then year number 11 the employer says, not going to happen.
See, I could see an employer doing that as long as it gives the employee enough advance notice.
Right.
If they tell them the week before, then it may be too late. Arrangements would have been made. But if they tell them a year in advance, for example, just so you know, next year, I'm not going to be able to have you take that week in June off. Okay.
Yeah.
But depends on time, being reasonable. The law oftentimes, John, is about what's reasonable. And it's not reasonable to cancel someone's vacation after they've already made arrangements.
Severance in a unionized environment. We will tackle that after a short break. That is coming up. Want to reach out to Lior anytime. 1-855-821-5900. Employment Hour in 30 continues. Hang on.
You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to inyourcorner.ca. You thought you had a secure job. You didn't see it coming. Now what do you do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back to Employment Hour in 30, employmenthourtv.ca, the place to go to catch the radio show where you can hear it each week. We've been doing it for over 7 years, got a ton of phone calls on that show every week, and we'll play phone call number 3 back right now.
Last Wednesday, I received a written notice that my employment will be terminated, and I was escorted from the office. There's no specific cause of the dismissal, rather than the business is very slow. So my question is basically because I worked for the company from 1998 to now. Am I entitled to severance pay? I had a manager position and around $140K.
Yeah.
Well, absolutely. Absolutely. And for the company, that may be a huge bill. The company may be slowing down. The company may not be doing well financially. But legally, that doesn't relieve them of their obligation to pay severance pay just because the company is struggling financially. I'm not saying I don't feel the company's pain in that sense. But legally, I can only tell you what the law is. This is not my opinion. They can't avoid paying severance. So assuming what this person is saying is right, she lost her job. business is slowing down, the company is slowing down, whatever it is, yes, of course she is owed severance. Now, she's a senior employee, a manager making a good salary, 21 years of service, significant entitlements. SeverancePayCalculator.com. Let's put that on the screen so that we can see how much she's owed. Again, a manager, 21 years of service. I picked an age, let's say she's in her early 50s. She's already told us she makes $140,000. Severance she's owed is 24 months' pay.
Done.
She asked us, am I entitled to severance? The answer is you're owed 2 years' pay, and at her salary, that's $280,000. I'd call that a bit of severance.
Yeah.
I don't know about you.
That'll hold you over for a bit.
For a couple of weeks at least. But bottom line is, company's slowing down. You lost your job for whatever reason. As long as you haven't done something terrible, stealing, hitting someone, of course you're owed severance. Again, SeverancePayCalculator.com.
Questions other than the phone number and the radio show and this TV show, terminationquestions.com is where you want to go. Second one from that website, pal, is I was just let go from a manufacturing plant where I worked as a supervisor. I'm not part of the union, but some of the other workers who were fired are unionized. Can you help me and the others get severance pay?
So we've already established that I can help, an employment lawyer like myself can help the non-unionized employees to get severance. Of course, SeverancePayCalculator.com, absolutely easy. But I wanted to bring this up here today to talk about the unionized employees. I get calls, I get emails daily, multiple times a day, from unionized individuals wanting to know how can I help them and how to deal with their workplace problems. Here's the thing, John, and this is not a Lior thing. This is not about me or my preferences. An employment lawyer, any lawyer, cannot help a unionized employees. Not that we don't want to, not that we choose not to. We cannot. Doesn't matter if we wanted to. I want to. It'd be good for my business. I'm not complaining. I cannot, and no lawyer can. The only one that's allowed to help a unionized employee in a workplace dispute or a workplace problem is the union. You can't hire a lawyer. You can't deal with it yourself. You can't even go and file a complaint with the Ministry of Labor. It has to be the union. Now, the natural question is, well, what happens if the union won't help me? Or if the union is not doing a good job? Or maybe I don't trust the union for whatever reason. Which is why I get the calls. Yeah. That doesn't solve the problem. Unfortunately, even if the union is not doing what you want the union to do, it still has to be the union. You can't get out of from under the union has to do it. Now, in extreme situations where the unions really drop the ball, you are able to file a complaint against the union with the labor board. We call that a duty of fair representation complaint. Yep. I can tell you in my experience, those types of complaints are rarely successful, very, very rarely. So bottom line is, the reason why I tell you I can't help you is not because I don't want to. I do want to. It's because I am not allowed. I cannot help you. Only the union can help a unionized employee.
We'll get to this one very quickly here as we wrap up. TerminationQuestions.com. Again, my boss just told me that he wants to shift many of my responsibilities to a new hire. After 6 years on the job, this change will be embarrassing and will make it hard to work with coworkers and clients. I can see why.
Absolutely. So obviously a demotion, a straight up demotion is something a company is not allowed to do. It's a constructive dismissal. Yep. But in some cases, you may not necessarily be demoted. It's more of a lateral move. And the question is, can they do that? Well, it does depend on how this impacts you. If it does reduce your stature in the workplace, if it does make it hard to continue working, if it's somehow embarrassing, then that is still something that the employer cannot do, and it can also be a constructive dismissal. Just because you haven't been demoted, but your job has changed, does not mean you don't have rights. In this particular situation, because it's going to be embarrassing, difficult to continue working, even without a regular, obvious demotion, that would be a constructive dismissal. It would be something that allows you to say, I'm not accepting this, but if you're going to insist anyway, employer, I, the employee, I'm going to treat that as a termination and leave with my full severance. So that's the option that you have. You can do that if your job changes.
And that applies even if there's no salary change. It's just a...
Absolutely. If your job changes, the salary may stay the same. But again, it's embarrassing. It's difficult to continue working. Maybe it's a job you had 25 years ago. You don't want to go back to it. It's going to look bad on a resume. Right. No, you can absolutely treat that as a constructive dismissal. Now, if the job changed and the pay changed, it's even that much more obvious. Yeah. But even if the pay is the same, it could still be a constructive dismissal.
Always SeverancePayCalculator.com, help at employmentlawyer.ca through email and 1-855-821-5900. All the ways to reach out. Get a hold of Lior and the team. We will catch you next time right here on Employment Hour in 30.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.